Alex here with part 31 of the My Docket series on child custody and visitation. For those of you who haven't seen it yet, please take a look at part 0 of the My Docket series. That is the video that contains the detailed disclaimers and the underlying purpose of this series. Two things that I will quickly glaze over are, number one, I am not in the middle of this right now. My case is completely and totally closed. It cannot be reopened. My ex's parental rights have been terminated. And number two, the nutshell version of the purpose of the series is to give my viewers one gigantic example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We left off with having taken a look at my review hearing video, which was, I believe, a 1.5-hour video. And it could have gone better, but in hindsight, a 25-year-old representing himself in court against an attorney without any experience, it looks a lot better than I think. I imagined myself looking a lot worse. And when I actually looked at the video, there were some cringy parts. However, now that I've had a day or two to think about it, I really am starting to see that even back then, while I didn't know the statutes, rules, and case law that I do today, I still had some good gut instincts, some good understanding of logic, and that seems to have driven me in the correct direction when it came to a lot of the things I said. And there were still a few things that I can understand why I said them. However, they really didn't help my case, or they made it worse. And the one glaring mistake that I made was just consenting to not having my ex's mental health records. Now, I do not think I had a right to those mental health records. Well, I'm not going to say I do not think. There's a possibility that I didn't have a right to the mental health records at that time because the case settled. But there are numerous occasions later on in the case where they become relevant, and without question, I had a right to take a look at them at that point in the proceedings anyway. Even that being said, I still am skeptical that even with having settled the case, it's in the best interest of the child for both parents to have that kind of information. And I spent a little bit of time talking about it in part 30. So if you want to take a look at the video, if you haven't seen it yet, definitely take a look at that video. In fact, if you haven't seen it yet, that's indicative you might not be watching the series in order. And you're going to get the best out of the series if you watch it in order. So this is going to be a little odd, but we're going to be looking at a court order that was entered that is not the court order stemming from that hearing that we just watched in part 30. It's the court order that my ex and I were arguing about. There were documents filed. I went over them, I believe, in parts 28 and 29 of the My Docket series. I'm not 100%, but I do believe those two videos cover that dispute. And there was such a delay in getting that order signed that we actually ended up going to another hearing, and it was discussed at that hearing. The written order entered by the judge on my objection, on my ex's assertions with regards to what should be in that order, there was a portion of it that was discussed at that hearing, and that was the portion with regards to whether or not I waived my right to a trial. And I don't really have much to say with regards to my mindset, aside from the fact that I felt like, I was on cloud 9. I was elated because I came out of that hearing confident that I was going to get joint physical custody. The judge had pronounced from the bench that I was entitled to it, but at that point, all I was waiting for was the actual written order stating it in black and white with his signature. And that is coming. However, this happened to occur before that. And what I mean by this is this order stemming from not the last hearing, but the one further back, the settlement conference in part 27 is what I'm talking about. That order ended up getting signed first. So now let's go ahead and take a look at what our judge has filed. Here we have the order after hearing entered by the court. First paragraph, as with previous court orders, it's a brief summary of what it's stemming from and who was present. So in this case, this order is stemming from the settlement conference held on the 10th of February. That video is in part 27 if you want to review it. And I appeared representing myself. My ex appeared through her attorney. It might seem like deja vu to a lot of people because we've gone over a proposed order that was very close to what this order ended up being in the end. There was, I think, 2 provisions at the bottom that were changed based on the judge's response to my objection to my ex's attorney's proposed order. And then I think that the portion of the order that waived my right to a trial was removed following the hearing, because even though the judge ordered that that was actually true, at the hearing, he realized that that wasn't legal and basically took it back. So I do not believe that my ex's attorney put it in this document, but we'll find out in a moment. The first thing we can I think I mentioned this before, you can take a look at the proposed order that I was just talking about. I believe it is in part 28 and part 29 of the My Docket series. So tape record conversations with each other, that was preserved from the proposed order. Child support is suspended. I'm to pay arrearages in 30 days in the amount of $52.60. She was petty like that. She really brought this up a lot, the fact that I was behind my child support on for $50, and so he went ahead and put that in the order, or went ahead and asked for that to be put in the order, and this was easily paid off. The updated financial declaration, this is because I worked at Circuit City when they went bankrupt, so he just indicated that once I start working at a new place to let her know within 30 days. Let's see here, and that probably had something to do with why my child support was suspended, especially since she was making like 3 times what I was making while I was working. Supposed to pay for the child's medical insurance premiums. There is something here that I'm realizing only now, and I'm drawing on this realization given all of the experience I have with going through this ordeal with my ex. When she asked for these premiums to be paid, I'm fairly sure I agreed to it. I don't see why I would have objected to it. But what happened afterwards seemed innocuous at the time, and actually is obvious to me that it's a problem now because I have the benefit of hindsight to go over it. But the medical insurance premium was in fact $75.46. What was interesting, what my ex did after. So when the judge ordered this to be paid, she immediately went and upgraded her insurance to include dental and vision. If anyone knows anything about insurance, dental and vision really isn't that high. But what she did after she updated it is she sent me an email saying, hey, you need to pay more than just $75.46. And I responded saying, what are you talking about? The court ordered $75.46 for medical insurance. And she indicated that she increased the insurance by getting the dental and vision. And at the time, I just figured, well, I guess there was something that was misstated in court. I suppose her attorney gave the judge the wrong amount, and so the amount wasn't correct. There was some argument over that. And later on, throughout the case, she would take similar steps to try to ramp up these expenses and make a big deal out of it. And I didn't really think it was a big deal. So she would go to a dental appointment, she would go to a vision appointment and get all these extras. And she couldn't get extras that were outside of the, the out-of-network expenses. It had to be in-network stuff. But I didn't really question it at the time. It took me until about year 7 or 8 before I realized that she was deliberately trying to find a way to spend money as long as that would force me to have to reimburse her 50%. And to a lot of people, that probably sounds like it makes no sense. Why would somebody cause their ex to have to spend a certain amount of money if they would also have to spend it as well? Like, why cut off your nose to spite your face? Well, she's not really rational. She wasn't a logical person. She was vengeful. She was angry. She was hateful. And the moment that I realized this, because I think I mentioned it was like 5 or 6 years before I figured it out, this was after I ended up getting primary physical custody. And what happened was there was an order that anytime she visited our son, given the fact that we had separated distance-wise, I had moved from Reno to Vegas. Anytime that she visited him, she was entitled to 50% the reimbursement. And she started to do some pretty crazy things. She would buy tickets the day before or 2 days prior when they were most expensive. And I kind of thought maybe she's procrastinating and she's just doing this last minute. But then she would go and get hotels, the most expensive rooms that she could get. One of them was a $500 a night stay. And I had to say, I'm not paying that. You're entitled to the transportation costs, but I'm not paying for your hotel. And this ended up being brought up in court, and the judge was livid. Because the judge at first thought I was trying to go, violate the court's order. And I was like, Your Honor, you ordered her to get half the transportation costs. And they are $300 for the flight. And the judge was like, what? Why was it so much? Well, she keeps getting it the day before, over and over again. And then there was the hotel stay for $500. So the judge went ballistic on her. And I realized, it dawned on me then and there, that any opportunity that she had to cause me to have to spend money, she was going to exploit, even though it would also cost her to have to spend money. And it got to the point where I even mentioned in a video, whatever you do, make sure that you put provisions in your court's order with any reimbursement that wasteful expenditures are not reimbursed, because they will do that. They will cut off their nose to spite their face. And one of the best things that you can do when it comes to insurance reimbursement, out-of-network, I kind of jumped ahead of myself a little bit there. One of the things that you could do with out-of-pocket expenses on medical, dental, and vision care is to get it written into the court order that you do not have to pay out of pocket, or you don't have to reimburse 50% of out-of-pocket expenses if your ex takes the child to an out-of-network provider, because as anyone here might know, you have to pay a whole lot more when you go out-of-network versus in-network. So that is something that didn't happen to me because I had that put into the order, but it has happened to other viewers on my channel. They have had situations where they didn't clarify. It was just, one person pays for the insurance, the other person pays half the premium. Any out-of-pocket costs are split 50-50, and there would be a high conflict parent, personality disordered, or maybe emotionally immature, that would deliberately take the child to out-of-network providers and demand thousands of dollars in reimbursement. And it's just so hard to get your head around it, because they don't get that full amount back. If they were able to ding you for $1,000, they ding themselves for $1,000, but they just don't care. So anyway, that's what this actually ended up turning into later. And you can watch this in part 30 of the My Docket series. I'm just like, you know what, I'll just pay it. But that's what she did. As soon as the judge ordered that I was to pay half of these premiums, she went and got she got the vision and dental and demanded reimbursement of those as well. So I do not think at the time that was pure coincidence. Given the hindsight that I have following all those years of litigating against her, it's clear to me that was just one other way in which she could maximize what I would have to spend. Scrolling down. Psychological records. She shall turn them over to, there's going to be an in-camera review, which I've talked about a little bit in part 27. Just for anyone here who doesn't know, an in-camera review is an opportunity for the judge to review proposed evidence to determine whether or not it's relevant. And it's meant to be a mechanism by which the judge can protect a party from having their sensitive information unnecessarily exposed. And that is because if the judge deems that the evidence is not relevant to the case, the judge can refuse to allow it to be introduced into the case, and thus that person won't have to share it with the other party. If the judge determines that the evidence is relevant to the case, then the other party is entitled to have the evidence. And I do want to mention here that I did make a mistake when I was representing myself. I didn't know this. And so I was not able to get those documents. And throughout the years, I frequently made demands for those documents, but I didn't know that I had really any authority to get my hands on them. Had I known that, I would have forced the judge to have it disclosed to me, either by filing an appeal or by filing a petition for writ of mandamus, one of the two, whichever one was the appropriate remedy. Scrolling down. I like that the judge commanded or directed my ex to send these records directly from the hospital to the court. That's a very smart move on his part, because she would have likely accidentally lost some of the paperwork, specifically the paperwork that was very damning to her case. So the judge did end up getting these records transmitted directly from the hospital to him, and they did end up alarming him. But at this point in time, when this order was entered, he had not seen them yet. And so what this order is indicating is that eventually he will see them, and he will determine in camera if those records impact a custody determination. Oh no, it is here. So that last sentence, if the court determines that there is nothing in the records that impacts a custody determination, then there will be no trial. She didn't remove it. She left it in the court's order. So that is still there. But if you've watched part 30 of the My Docket series, the judge has decided, he made a pronouncement from the bench that this portion of the order is not enforceable because my right to a trial on the issues is not actually waived, despite the fact that it was entered into this order and signed. Next line here is psychological records, mental health records. After the court reviews them, it will be determined whether or not the next hearing will be in court or via telephone. Next provision discusses holiday visitation. Nothing here really jumps out at me as important to the viewers. Let's see here. Holiday visitation, again, let's just scroll past these. Vacations. I really like this method of declaring vacations. You basically give each other 30 days notice and you get vacations. I mean, there's a certain number of days that we each cap out at. I think it's 15, but what I'm reading here is 7. It says that they have to be less than 7 days. I don't see anything here about 15 days max, though. Interesting. Somewhere along the lines, there's a limit to how many of these can be done. Maybe it comes up later. One of the things that I want to mention is this 30-day advance notice thing ends up getting reduced to 14 days because she starts to deliberately violate the court's order. She would give me like 5 days notice, 10 days notice. And it's kind of like a way that she could give me the opportunity to refuse so that she could then turn it around and use it against me in court. I talk about this a lot in part 30 of the My Docket series, but I'm not going to go into it again. It will come up throughout the case frequently, and I'll bring it up each time it does. Phone calls. Calls have to be received before 8 p.m. This order ends up being changed immediately thereafter. After the review hearing, this order is changed once again, and that phone call, the threshold of 8 p.m. gets pulled back to, I think, 7:30 p.m. More holiday stuff. Here's the portion of the order that was changed to be reciprocal. It was lines 14 and 15, and the court is just ordering that parties need to share the name, address, and phone number of the person who babysits the child. This here is the boilerplate. This penalty for violation of order is included in pretty much every single order in Nevada that has to do with child custody, and that's by law. There's a statute in Nevada that mandates that any order entered in a domestic relations matter, maybe it's specific to child custody. Yeah, it is. Any order entered in a child custody matter has to include this provision here at the bottom, letting parents know that you can't abduct your child, you can't detain your child in violation of the court's order, etc., etc. Here in the bottom left-hand corner, you can see who prepared the order. That's my ex's attorney's signature. I think there's a local rule that requires that. Certificate of mailing by the court clerk. It just indicates that the document was served to myself and my ex. Well, her attorney. Moving on to the next document, we have the minutes. The minutes, I've gone over these quite a few times in the past. It's just a brief summary of what occurred at the hearing. You can't actually use the minutes you can't use them in a way as a substitute to a court order. Let's put it that way. The minutes are not a court order. And so you can't use them on appeal, like you can't appeal from minutes. And you also can't use them to hold somebody in contempt of court. They don't count. They're not binding. It's just what somebody who was listening in on the hearing felt, was discussed. It's not actually the directive of the judge. But these are frequently used by paralegals or judicial staff to prepare an order. And you know, that's totally fine. You can also always get more details by pulling the video itself or the transcripts. But you could think of minutes as sort of a summary of what happened at a hearing. And I'm going to take a look really quickly here. Nothing jumping out. At all. Everything here was for the most part reduced into a court order, which we just went over. It's quite a long set of minutes. It looks like, I mean, it really summarizes everything in pretty good detail, more detail than I would expect. A lot of stuff in there about Second Amendment. Parties will have joint physical custody. Visitation, 2 p.m. Nothing really alarming, nothing jumps out. Going to go ahead and move on to the next document. Notice of entry of order. I've gone over these before as well. In fact, I have a video dedicated to these. Take a look at the video Notice of Entry of Order if you want to learn the purpose behind them, because they are mentioned in the rules and they are specifically connected to the deadline as to when you can file an appeal. I'm not going to reiterate any of that right now because, as I mentioned, I have a video dedicated to just this topic. But it's an important video to watch, especially if you're in Nevada. Even if you're not in Nevada, you may be in a state that has a similar provision that the deadline to file an appeal is based on not when the order was entered, but when the notice of entry of order was filed. Index of exhibits, and I'm not going to need to go through this. I'm going to pretty much stop here because that exhibit is the order after hearing, which we just went over anyway. Going into the aftermath, I didn't prepare or file any of these documents, so I incurred $0 in costs. My ex's attorney filed a notice of entry of order. That's a free filing, so she incurred $0 in costs as well. I have no attorney, so I incurred $0 in attorney fees. My ex's attorney probably put 10 minutes into preparing the notice of entry of order. She probably didn't even actually prepare. It's probably one of her staff, and they just have to like open up one of those form documents and change the names and the caption, the case number, staple an order to the back of it. It's really one of those very simple, repetitive filings. The order after hearing, she prepared herself, and we already counted that time in preparation against her attorney fees in a previous video. So the only thing she probably have to review here is things that the judge scribbled out and replaced, you know, with his pen, like manually. And he did actually do that. He replaced a couple of words in that order after hearing. So 5 minutes is what I'm going to say it took her to review it, because nothing substantially changed at all. She probably didn't even have to call her client. So we're at 15 minutes so far. The minutes are pretty thorough. They're not as important because they don't count as a court order. They're not binding. They might be of some concern if something is very different in the minutes, but not in the sense that it's going to have any effect on the case. It's just sort of a better keep my eye out for this if that proposed order includes that erroneous thing. In this case, those minutes are pretty thorough, but there's nothing at all that's jumps out as alarming or erroneous in them. So I'm going to go ahead and say 15 minutes again. So we have 30 minutes, and at a rate of $250 an hour, my ex's attorney probably charged her $125 in attorney fees. If you have any questions, you can post them down in the comments below, or you can send me an email at admin@theproperperson.com, and I will see you guys next time.